Now, if the decision is to terminate the seller plan prior to close, this is most commonly used when the buyer will provide its own plans to employees of the former plan to sell the plan. Some considerations apply here as well. Number one is that it avoids the acquisition of additional risk and unexpected fiduciary liabilities. The plan is terminated, and that's the only clear way to avoid liability to carry forward. It avoids the additional administrative burdens, the protected benefits, maybe dual record keepers, testing issues, but 100% vesting is required for the terminating plan. So all participants under the plan that's being terminated must be 100% vested. It is a distributable event for participants, so benefits are distributable from a terminated plan and have to be distributed as soon as practicable. Word of caution for terminating plans, however, and if a plan is terminated after the closing date and the buyer maintains a separate 401k plan, the successor plan rules may apply, and they include that the acquired employees cannot participate in the buyer plan for 12 months following post-close termination, or the participants cannot take distributions from the seller's plan. And that typically defeats the whole purpose of terminating the plan, which is can't get the assets out. Let's discuss acquisition due diligence. We talked about the problems. This talks about how to avoid many of them. First, many of the unexpected and unintended complications and fiduciary liabilities can easily be avoided with proper planning during the acquisition process prior to the close of the deal, an important first step in regards to plan qualification. Definitely, it's worth everyone's time to determine that the plan is qualified under the Internal Revenue Code, Section 141A. And that's not an easy thing to do necessarily, but you can do your due diligence to do as much analysis to determine if that plan is actually a qualified plan under the IRS code. If not, pretty significant tax and monetary consequences can apply if a plan proves to have a defect that would generate a qualifying problem for a plan. Possible defects that could cause a plan to lose qualified status include plan document that doesn't comply with the code to begin with. In other words, recent amendments may not be executed. Plan is not addressed or administered in accordance to the terms of the plan document, which is the most frequent cause of fiduciary breaches, and the plan is discriminatory. It favors highly compensated employees with respect to coverage or contribution to benefits. Now, these are not far-fetched plan qualification issues. These certainly can happen at any time with any plan, particularly those that are not well managed. That's why it's important to try to make this qualification. As a result, these defects may taint and probably will taint the qualified status of any plan with which disqualified assets are transferred or merged. Other items to review during the due diligence process include probably the most frequent cause of fiduciary breach, which is delayed 401k contributions. Most plan sponsors do not understand that ERISA views late contributions as a loan of plan assets to the sponsoring company. Not particularly intuitive, but that's ERISA. Number two, compliance with 404C. If the plan is out of compliance, this may transfer over to the successor plan. And plans don't even know if they're in compliance or not. They can't know until they're tested in court for sure, but they can attempt to comply with 404C. So you want to make sure that the plan has done so. Other operational issues, including the most frequent causes of fiduciary breaches, which are unintentional administrative errors in either the interpretation of the plan document or the interpretation and administration of ERISA. Plan coverage rules cause problems. Eligible employees, as defined in the plan document, must be covered by the plan. The classic case is, well, we'll eliminate the eligibility of part-time employees. Well, ERISA doesn't know what part-time employees means. It's an hours requirement or a service requirement. That's no such thing as part-time employees to ERISA. Now, that has changed a little bit with recent legislation with the Secure Act on long-time part-time employees, so something to be aware of. Comparison of the seller plan and the buyer's plan must have a process for determining protected benefits. There are certain benefits that are protected for participants that if the plan transfers over, is merged, those protected benefits, as I mentioned earlier, have to be maintained, and that is a plan qualification issue.